In this video, we're going to be continuing with our discussion about the variation of trusts, and specifically we're going to be looking at the statutory powers associated with the variation of trusts. So firstly, the variation of powers of investment. And Section 57 of the Trustees Act 1925 says the following: where in the management or administration of any property vested in trustees, any sale, lease, mortgage, surrender, release, or other disposition, or any purchase, investment, acquisition, expenditure, or other transaction is in the opinion of the court expedient, but the same cannot be effected by reason of the absence of any power for that purpose vested in the trustees by the trust instrument, if any, or by law, the court may by order confer upon the trustees, either generally or in any particular instance, the necessary power for the purpose on such terms and subject to such provisions and conditions, if any, as the court may think fit, and may direct in what manner any money authorised to be expended and the costs of any transaction are to be paid or borne as between capital and income. So basically, this gives the power of variation for administration and management costs. So sometimes managing a trust gets pretty expensive, and if the trust is silent on whether they can change things to stop it from being so expensive, the statute says the trust can be varied to cover administration and management costs. So this subsection overlaps the emergency jurisdiction that I discussed in the previous video, and it widens it by making the statutory jurisdiction available in cases of expediency rather than emergency. Okay, it is only available in questions arising in the management or administration of the property too. Okay, it is not therefore available for the purpose of remoulding beneficial interests or for tax saving more generally. And so we've got a case here of Thomas and Thompson from 1930, and in this case the trustees wanted to sell land but were unable to get the joint consent of the beneficiaries. So here the trustees wanted to do something and needed the consent of the beneficiaries to do this, but the beneficiaries were in dispute as to whether this can be done, and the court allowed a variation to partition the trust property between the life tenants. So the court said that the trust could be varied to allow for the partition of the trust property between the life tenants, and those who wanted to sell can sell. And we've also got this case here of Shipwrecked Fishermen, and this was a charity founded by an Act of Parliament whose investment powers were restricted to mortgages of property and government securities. This meant that the capital of the charity was being steadily eroded. The charity therefore applied to the court for power to invest in industrial and commercial companies on the stock exchange, and the court held that it could allow for a wider power of investment by Section 57. So this is a compromise but has the effect of salvaging the trust property. So it doesn't have to be one or the other, it can be both. Okay, and then we've also got this case of Mason and Farbrother from 1983. And in this case, the trustees of a pension scheme had limited powers of investment. There was some doubt as to the meaning of the investment clause in the trust instrument and whether the trustees could invest under the powers granted by the Trustee Investments Act 1961. So there was something in the trust instrument, but they were unsure exactly what it meant, and they were confused by this trust instrument and didn't know whether they could use the powers given by the Trustee Investments Act. So they came to the court for help, and the court held that while it did have the jurisdiction to approve a compromise, which would include the jurisdiction to vary the investment clause, it doubted whether the jurisdiction would extend to approving an entirely new investment clause. However, the powers under Section 57 of the Trustee Act 1925 did allow the court to make such a variation. So the court didn't know whether it itself, absent the Trustee Act, could allow this variation for a whole new clause, but the court said that the Trustee Act 1925 gave them that power. So because of the statute, they could allow the variation. Okay, so that's a little bit on the variation of the powers of investment. But what about more generally, the general powers to vary trusts? And that comes under the Variation of Trusts Act 1958. And the court has a general jurisdiction under Section 1 of the Variation of Trusts Act 1958 to sanction any arrangement by whomsoever proposed, and whether or not there is any other person beneficially interested who is capable of assenting thereto, varying or revoking all or any of the trusts, or enlarging the powers of the trustees of managing or administering any of the property subject to the trusts. This power must be exercised on behalf of specified classes of person, which are those without capacity by virtue of age or mental incapacity, those whose interest is not yet vested, and those unborn who may become beneficiaries. So this statute, the Variation of Trust Act 1958, says that the court can act on behalf of beneficiaries who are unable to consent to the beneficiaries. For example, if they are unborn or just a child, etc. This is also one instant where the trust instrument cannot trump the statute. Okay, so all along in all my previous videos, I've essentially been saying that the trust instrument is the most important thing, but this is one instant where the trust instrument itself cannot actually trump what is said here in the Variation of Trust Act 1958. And so we've got this case of Steed's wills trusts from 1960. And in this case, there was a proposed sale of a farm by the trustees, which was opposed by the beneficiary. So we have a dispute between the trustees and the beneficiary here. And Lord Evershed said that if that is right, it then follows that the court must regard the proposal as a whole, and so regarding it, then ask itself whether in the exercise of its jurisdiction it should approve that proposal on behalf of the person who cannot give a consent, because he is not in a position to do so. If that is a right premise, then it follows that the court is bound to look at the scheme as a whole, and when it does so, to consider, as surely it must, what really was the intention of the benefactor. The court did not overrule the trustees. In this case, the proposed variation was not in the interest of the beneficiary's spectral husband. So here we have a woman whose husband was spectral. So the court determined it was not in his best interest. He wasn't there to consent. And, I think he was actually in a different country or something. So the court spoke on his behalf and let the trustees do what they want. Okay. And we've also got the case of Tinker's settlement from 1960. And in this case, property was held on trust for a brother and sister. The trust provided that if the brother died before 30, his share would go to his sister, but if the sister died before 30, her share would go to her children, if she had any. The trustees regarded this as an obvious mistake and sought an alteration to the trust deed. So the trustees thought it was a mistake that the property would be left to the sister's children rather than her brother. So the trustees sought for this to be changed. And the application was refused. In other words, the court did not allow this variation. And Russell said that it seems to me that it is one of the weakest claims for rectification that I have ever seen, perhaps only rivalled by that in Constantinidi and Raleigh, which was referred to in an argument, and I cannot bring myself to think that I would be benefiting the daughter's children if I gave away half of that which will come to the daughter's share if the son dies under 30. So the court said that they would take what is said in the trust on face value. They will not mess with the intended inequality of the settler. And we've also got a couple of other cases here. We've got Seale's marriage settlement from 1961 and Weston's settlement from 1969. And in these two cases, the trustee sought the variation of a trust instrument to allow the property to be transferred to another jurisdiction. And in the case of Seale, the family had emigrated to Canada, and in Weston, the family were moving to Jersey for tax reasons. So in the case of Seale, the variation was actually approved. So in that particular case, the court allowed the trust to be varied so that the property in question could be moved to Canada. In the case of Weston's settlement, the Court of Appeal distinguished in re Seale's marriage settlement, holding that going into tax exile was not for the benefit of the children. So I would actually recommend you read the Weston settlement case. It's a pretty funny case actually, and the judge does not like Jersey at all. So give it a read if you want a bit of a laugh. But in this case, they didn't follow Seale, so the children cannot go to Jersey. So the difference between the two cases was the timing of when they were. Was the timing of when they were moving, but they were both ultimately trying to avoid taxes. So the court will not approve an agreement which provides for a settlement under the law of a foreign jurisdiction if the beneficiaries remain resident in England, nor as in Weston, where the connection with Jersey, the foreign jurisdiction, was recent and tenuous, and where the court doubted whether the living beneficiaries really intended to make Jersey their permanent home. Trusts, however, have been exported in favour of a settlement with foreign trustees and governed by foreign law, where the beneficiaries have emigrated permanently to the foreign country, as in the case of Seale. And Lord Denning says that, I do not believe it is for the benefit of children to be uprooted from England and transported to another country simply to avoid tax. It was very different with the children of the Seale family, which Buckley considered. That family had emigrated to Canada many years before with no thought of tax avoidance and had brought up the children there as Canadians. It was very proper that the trust should be transferred to Canada. So this is how we got around it in Seale. They didn't just move to avoid taxes, but had already moved to Canada. They came back saying they needed to vary the trust. So that was fine. In Weston, on the contrary, they were moving just to avoid the taxes, so there was no pre-moving like in Seale, and that was the legal argument. But Weston is also funny because the judge is adamant that nobody would want their grandchildren to live in Jersey, and yeah, as I said, give it a read. However, as a general rule, avoiding tax is to the benefit of the beneficiaries, and courts will approve variations for that reason. So, in general, if it avoids them losing money, they would allow it. And Harman says that this is an essay in tax avoidance, naked and unashamed, and none the worse for that, says the applicant. Indeed, the judge agreed that this court is not the watchdog of the Inland Revenue, and it is well known that much, and perhaps the main use which has been made of the Act, has been to produce schemes of variation of English trusts, which will have the effect of reducing liabilities on the capital of the trust or the income of the beneficiaries. At the time, income tax was 41.25% with a surtax of 50% payable on income over the threshold. So if you want to vary your trusts, move to the new jurisdiction first, then come back and vary the trust at a later date, okay? Don't try to vary the trust and move at the same time, okay? That probably won't be allowed. And then finally, new settlement. So where a variation of trust amounts to a new settlement, the new trust is subject to the rule against remoteness of vesting and the rule against perpetuities. So if your variation of trust sets up a new trust, that new trust will be subject to those rules and the rules against remoteness of vesting, the rules against perpetuities, etc. Of course. And if you want, I would recommend you check out my videos on remoteness of vesting and the rule against perpetuities if you want to learn that in a bit more depth. While the perpetuity period for trusts created after April 2010 is 125 years, the period for trusts and wills executed before that date is a life in being plus 21 years. A variation of a trust created before that date which meant that the property would not vest absolutely within the original perpetuity period, would be void. So the case of Pilkington and IRC says, as with advancements, if variations will save the trust from falling for perpetuities, the court will allow it. Okay, now as I said, if you have any particular questions about perpetuities and remoteness of vesting, etc., check out my other videos on those topics, and I can answer any further questions you may have about that on those videos or below. And if you have any particular questions about variation of trusts, and specifically variation of trusts with regards to the statutory rules, then please leave a question below and I'll get straight back to you as soon as I can. But if you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.